Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, official listener learners. I welcome all respected doctors and directors. I welcome all honorable ministers and managers. I welcome all honorable advocates, advertisers, administrative advisors, the most honorable President Prime Minister Modi ji, Dr. Rakesh from USA, thank you for providing your valuable time. It is really nice time, nice place, nice session today. We are explaining, describing, mentioning our holy Indian cultural land. Our holy Indian cultural, social, spiritual values are really praiseworthy, admirable and appreciable. Our holy Indian constitution gives us opportunity to spend maximum time with our spiritualistic and nationalistic, patriotistic feelings. Let us discuss today which justice is placed in Article 39A of the Constitution, an important instrument to realize that is public interest litigation. Let's explain it. Public interest litigation is an important concept of last part of 20th century. It is an important instrument to make available justice to poor persons of the society. In Article 39A of our Constitution, the presumption has been made to make available justice to public. To realize that presumption, to realize that presumption, it is a meaningful medium. A very large class of our society is of that kind which is unable to approach the court due to illiteracy, ignorance, and poorness. It is an easy approach to make available justice to such class through social and voluntary organizations. Actually, the public interest litigation is a powerful form of redressal of problems linked with public life. In the case of People's Union for Protection and Democratic Rights versus Union of India, EIR 99, EIR 1980, SC 1579, it has been propounded by the Supreme Court that the public interest litigation is considered an important part of rule of law in the democracy. The rule of law not only secures the interest of rich persons but also provides equal opportunity of justice to both class of the society. Assumption of the public interest litigation has been made for such persons who are unable to approach to court for any reason. Also, on behalf of many persons having common interest, it is an effective measure to get relief from the court by some person or by voluntary organizations. What is public interest litigation? Public interest litigation means such a litigation of judicial action wherein the interest of large group of public is vested. In other words, it may be said that such a litigation or judicial action in which public interest at large is vested is called public interest litigation. In the case of All India Railway Employed Employees Union versus Union of India, year 1981, SC 298, it has been stated by the Supreme Court that any person of the society, union, or organization can knock the doors of court for protection of legal rights of such a person or class who is unable to go to court due to poor economic condition or for any other reasons. It has been stated by it has been stated by ex-justice of the Supreme Court, Vision Iyer, that narrow concept of approach to court by the aggrieved and distressed person has now been come to an end. It has now been replaced by class activity. One is class activity, two is public interest litigation, three is representative litigation, etc. Now, any person who is attached to public interest for protection of such interest may approach to court. For example, everyone has interest in Ganga's water. Its water is used by general public, hence to save Ganga's water to be polluted. Any person having interest in that water may institute public interest litigation as the Mehta versus Union Bank of India, AIR 1988 FC 1115. Similarly, a public interest litigation can be instituted for the beauty of Taj Mahal because interest at large of general public is vested in Taj Mahal. In the case of MC Mehta versus Union of India, AIR 1997 SC 734, while ordering for removing approx 292 factories and industries nearby Taj Mahal. It has been stated by the Supreme Court that Taj Mahal, Taj Mahal is the king emperor amongst the world wonders. The Taj is the final achievement and acme of the Mughal art. It represents the most refined aesthetic values. It is a fantasy, like grandeur. It is the perfect culmination and artistic interplay of the architect's skill and the dweller's inspiration. The marble inlay walls of the Taj are amongst the most outstanding examples of decorative workmanship. The elegant symmetry of its exterior and the aerial grace of its domes and minarets impress the beholder in a manner never be beholder in a manner never to be forgotten. It stands out as one of the most priceless national monuments of surpassing beauty and worth, a glorious tribute to man's achievement in architecture and engineering. Its protection and preservation is our responsibility. In the case of S.P. Gupta versus Union of India IIR 1982 SC 149, it has been held by the Supreme Court that transfer of judges can be challenged by the advocates under Article 226 of the Constitution because interest of all vest in freedom of judiciary. In the case of Jammu Kashmir Council versus State AIR 2003 NOC 256 Jammu Kashmir, the right to the unpolluted water has been considered by the Jammu Kashmir High Court as a subject of public interest litigation. Subjects of public interest litigation. The list of subjects of public interest litigation is exclusive. It depends on the facts and circumstances of each case, whether it may be considered as public interest litigation or not. Generally, the following are considered under the subject of public interest litigation. Subjects of public interest litigation. The list of subjects of public interest litigation is exhaustive. It depends on the facts and circumstances of each case, whether it may be considered as public interest litigation or not. Generally, the following are considered under the subject of public interest litigation. One is bonded labor, two is minimum wages of workers, three is child abuse, four is women harassment, and five is police torture. Six is environment protection, seven is torture on Dalits and backward classes. Next is family pension. Its next is bad conditions of Nari Niketans. Further of it, abuse, harassment, and disorder in jail. Next is transfer of judges, inhuman behavior with prisoners, inhuman behavior with workers, to pollute Ganga's water, sexual abuse with blind girls, etc. The list of subjects of public interest litigation is exhaustive. The list of subjects of public interest litigation is exhaustive. It depends on the facts and circumstances of each case, whether it may be considered as public interest litigation or not. Bonded labor, minimum wages of workers, child abuse, women harassment, police torture, environment protection, torture on Dalits and backward classes, family pension, bad conditions of Nari Niketans, abuse, harassment and disorder in jail, transfer of judges, inhuman behavior with prisoners, inhuman behavior with workers, to pollute Ganga's water, sexual abuse with blind girls. The matters concerned with ecology and environment are considered as a subject of public interest. Litigation in the case of Mumbai Dyeing and Manufacturing Company Limited versus Mumbai Environmental Action Group AIR 2006 SC 1489. Sexual harassment of blind female children has been considered as a subject of public interest litigation in the case of Pratul Kumar Sinha versus State of Orissa AIR 1989 SC 1789. The matters related to minimum wages are considered as a subject of public interest litigation in the case of People's Union for Democratic Rights versus Union of India, AIR 1982 Supreme Court, SC 1473. At the last, it may be said that the following is required for public interest litigation. One is it should be in the interest of public at large. No personal interest should be vested in it, and it should be not be inspired by politics. It should not be inspired by politics. The cases inspired by politics are not considered under public interest litigation. In the case of Janata Dal versus H.S. Chaudhary, 1992, for SSC 305, it has been held by the Supreme Court that any matter inspired from politics cannot be considered as a public interest litigation. In the case of Dr. Y.S. Rajshekhar Reddy versus and Chandra Babu Naidu, AIR, to, AIR 2000, Andhra Pradesh 142, it has been held by the Andhra Pradesh High Court that a writ for removing Chief Minister due to non-election of municipality in time was not considered public interest litigation because it was inspired from politics. In the case of Kishore Bhai D. Panchal versus State of Gujarat AIR 2003, Gujarat 43, it has been stated by the Gujarat High Court that the object of the public interest litigation is neither to fulfill political aims nor to resolve political problems. In the case of Priyag Vyapar Mandal versus State of Uttar Pradesh AIR 1997 Allahabad 1, it had been stated by it had been stated by the Allahabad High Court that if a person institutes a writ with motivation of his personal interest, then it cannot be considered a public interest litigation. In the case of Simranjit Singh versus Union of India 1992 for SCC 653, it has been held by the Supreme Court that the matters of private interest cannot be sheltered under public interest litigation. In the case of Milan Kumar Pradhan versus Union of India, AIR 2000, Kolkata 5, it has been held by the Kolkata High Court that the matter of allegation of act or omission on public enterprise is not public interest litigation. In the case of Muhammad Kalimuddin Ansari versus the State of Bihar, AIR 2003, Patna 37, it has been decided by the Patna High Court that such cases cannot be considered public interest litigation wherein a request is made to High Court to direct for construction of roads. In the case of Prantos Rai versus the State of Assam, year 2000, Guwahati 33. Speedy trial has not been considered a subject matter of public interest litigation by the Guwahati High Court. In total, the criterion of public interest litigation is that it is linked with public interest at large. Letters, postcard, and cuttings of newspaper. The scope of public interest litigation has so extended in last days, and our apex courts provided relief to suffered parties by considering letters, postcard, and news of newspaper as a writ. Whatever it may be shared, that is, increasing of scope of public interest litigation or judicial activism, it is revolutionary step in judicial world. Many times the cases of public interest were brought into notice of the Supreme Court or High Court through letters, and the courts have provided relief in them as in the case of People's Union for Protection and Democratic Rights versus Union of India IIR 1982 SC 1473. The matter of non-payment of minimum wages to the workers employed in Asia project was raised through letter. Asia's project was raised through letter while passing orders for payment of minimum wages. The Supreme Court has stated that now in the cases of public interest, any person of the society or institution can make a motion or can make a motion of the court. Doors of court are not only open for industrialists, contractors, smugglers and wealthy persons. Doors of courts are not only open for industrialists, contractors, smugglers and wealthy persons, but also open for the poor person. In the case of MC Mehta versus Union of India AIR 1987 SC 1086, while considering a letter as a writ, it has been stated by the Supreme Court that a letter in the name of court can be accepted as a writ. In the case of Pratul Kumar Sinha versus the State of Odisha AIR 1989 SC 1783, orders for investigation and appropriate management were passed by the Supreme Court while considering news of sexual harassment of girls of blind girls school as a writ. In the case of Rajasthan Peasant Organization versus the State of Rajasthan AIR 1989 Rajasthan 10, a letter was wrote by a woman to the Rajasthan High Court wherein she alleged police for torture and irregularities. While considering it a case of public interest, appropriate orders were passed by the High Court. In the case of Sunil Batra versus Delhi Administration AIR 1980 SC 1579, cruel and inhuman behavior was done by the prison warden with a prisoner under life imprisonment in the prison, which was complained by another prisoner through a letter to the High Court. While considering this letter as a writ, it has been directed by the court to the officers of prison that there should be no cruel and inhuman treatment with the prisoners and an action be taken against the guilty employees. There are so many other such cases in which appropriate action was taken by the court while considering letters and news as a writ. SC Mehta versus Union Bank of India AIR 1982 SC 149. S.C. Mehta versus Union Bank of India, AIR 1987, SC 1086. Here it is to Here it is to mention that public interest litigation cannot be instituted if the civil suit is pending on that subject. Santosh Sood versus Gajendra Singh, AIR 2010, SC 593. What's the conclusion? The object of public interest litigation is to make justice available to downtrodden, etc., having regard to concept of human rights. Guruvayur Davasham Managing Committee versus C.K. Rajan, AIR 2004, SC 561. In the case of Bihar Legal Support Society, New Delhi versus Chief Justice of India, AIR 1987, SC 38, it had been held by the Supreme Court that the main objective of public interest litigation is to help a poor class of society and to provide equal opportunities of justice. In the case of State of Uttarakhand versus Balwant Singh Chofal, AIR 2010, SC 2550, it has been propounded by the Supreme Court that the courts should motivate only true and fair public interest litigation. A uniform procedure should be determined for public interest litigation. It should be ensured that public interest litigation is linked to public interest at large. The courts should motivate only true and fair public interest litigation. A uniform procedure should be determined for public interest litigation. It should be entered that it should be ensured that public interest litigation is linked to public interest at large. Malicious intention should be displaced. Main object of public interest litigation is to protect public interest. Next is Lok Adalat is a powerful form of making available speedy and cheap justice. Let's confirm this statement. Read in short notes on Lok Adalat. Permanent Lok Adalat. Lok Adalat is a powerful medium for settling the disputes between two parties by mutual peace and agreement. Lok Adalat is not a new name for India. Lok Adalats were prevailing in the Indian Lok Adalats were prevailing in the India in ancient time also. In the past, family and social disputes were being settled by mutual understanding by some reputed persons of village at Chopal of village. It was called the justice of Panch Parmeshwar. Somewhat in identical shape are today's Lok Adalat. The disputes between the parties are being settled in Lok Adalat by mutual agreement. Later on, these Lok Adalats were given legal form. What is Lok Adalat? The worldly definition of Lok Adalat has been given. Its definition is given in the Legal Service Authorities Act 1987, but that is also not worldly definition of it. In section 2, 1D of this act, only this has been mentioned that Lok Adalat mean a Lok Adalat organized under chapter 6. Characteristics. What are its characteristics? There are some its own characteristics of Lok Adalat, and on the basis of these characteristics, meaning and nature of Lok Adalat can be understood. Some main characteristics of Lok Adalat are as under. It is an Adalat of public. Lok Adalat is considered by mixing two words, Lok plus Adalat. That is Adalat of public. Adjudication in these adalats is done by the representatives of public or social workers. Their environment is not like a regular court. With all ease, the matters are settled. Form of compromise and agreement. Lok Adalat is form of compromise and agreement. Settlement of the case in this adalats is done on the basis of mutual compromise, agreement, and consent. The main object of it is to create the sense of brotherhood, to end enmity, and to create an environment of mutual cordiality. It is being said in respect of Lok Adalats that छोड़ो रंजिश भाई भाई लोक अदालत की गंगा आई. It is an adalat which reunite the relations. No party wins and no party loses in it. लोक अदालत का सार ना जीत ना हार. Source of speedy and cheap justice. Lok Adalat is a source of speedy and cheap justice. Neither long time nor money nor more money is required in settlement of cases under it. Technical or complex rules of evidence and procedures are not applicable in it. It works on the principle of equity, justice, and good conscience. Constitution. Provisions for constitution of Lok Adalats are laid down under section 19(2) of the Legal Services Authorities Act 1982. According to it, a Lok Adalat is consisting of serving or retired judicial officers and other persons. It is clear that the presiding officer of Lok Adalat is serving or retired judicial officer. Some other persons are also member of it. Such persons are having an experience in the field of art, literature, culture, law, just social service, journalism. There is sufficient representation of women in it. Social workers, advocates, and professors of law contribute especially in these Lok Adalats. Social workers, advocates, professors of law contribute especially in these Lok Adalats. Jurisdiction. According to section 19(5) of the Legal Services Authorities Act 1987, Lok Adalats have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of any matter which is falling within its jurisdiction and is not brought before any court. In this manner, jurisdiction of Lok Adalats is for such all matters which is under consideration with the court or which have not brought before any court. Such cases are called pre-litigation, conciliation and settlement. But such cases which are not legally able to compromise are not falling within jurisdiction of Lok Adalats. Generally, such cases are those criminal cases which do not come under purview of Section 320 of the Code of Criminal Procedure 1973. Meaning thereby is that such criminal cases which are coming under purview of Section 320 of the Code of Criminal Procedure 1973 can be settled by the Lok Adalats by compromise. In the case of Ramlal versus the state of Jammu and Kashmir, AIR 1999 SC 895, it has been held by the Supreme Court that such cases which are not legally able to compromise, those cannot be settled by Lok Adalat, and that can also not be made able for compromise with the permission of court. What are the powers of Lok Adalat? Powers of Lok Adalats are mentioned under Section 22 of the Legal Services Authorities Act 1987. Lok Adalats are considered as civil courts, and the following powers of civil court prescribed under the Code of Civil Procedure 1908 are provided. The summoning and enforcing the attendance of any witness, and examining him on oath, the discovery and production of any document, the reception of evidence on affidavits, the requisitioning of any public record or document or copy of such record or document from any court or office, and each other matters as may be prescribed. All proceedings before Lok Adalat are deemed to be judicial proceedings within the meaning of Section 193, 219 and 228 of the Indian Penal Code 1860. Every Lok Adalat are also deemed to be a civil court for the purpose of Section 195 and Chapter 26 of the Code of Criminal Procedure 1973. What is the procedure of Lok Adalat? The working procedure of Lok Adalat is mentioned under Section 20 of the Legal Services Authorities Act 1987. According to it, where a party wishes to settle in case through Lok Adalat, there such party will makes an application to the court for referring the case to the Lok Adalat for settlement. On receipt of such application, it will be considered by the court, and if such court is prima facie satisfied that there are chances of such settlement, or the court is satisfied that the matter is an appropriate one to be taken cognizance of by the Lok Adalat, the court shall refer the case to the Lok Adalat. Prior to referring the case to Lok Adalat, a reasonable opportunity of being heard to the parties will be provided. On receipt of the case, both the parties will be heard and efforts shall be made to arrive at a compromise or settlement between the parties. At the time of compromise, Lok Adalats have to follow the principles of equity, justice and good conscience. In the case of Moni Mathai versus Federal Bank AIR 2003 Kerala 164, it has been held by the Kerala High Court that Lok Adalats are bound to follow the principles of equity, justice and good conscience. Where no award is made by the Lok Adalats on the ground that no compromise or settlement could be arrived at between the parties, the record of the case shall be returned by it to the court, from which the reference has been received for disposal in accordance with law. Where no award is made by the Lok Adalat on the ground that no compromise or settlement could be arrived at between the parties, Lok Adalat shall advise the parties to seek remedy in a court. Such court shall proceed to deal with such case from the stage which was reached before the case was referred to Lok Adalats. In the case of National Insurance Company versus Kartik Goren AIR 2010, Jharkhand 59, it has been held by the Jharkhand High Court that for finalization of the case by the Lok Adalat, it is necessary that written consent of both parties be obtained and the procedure prescribed under section 22C 7 be followed. Procedure on arriving at compromise or settlement. On arriving at compromise or settlement in Lok Adalat under section 21, an award will be passed by the Lok Adalat, to which such award shall have an effect of decree of the civil court. Which such award shall be binding upon both parties. This no appeal shall lie against this award. Next is where a compromise or settlement has been arrived at, the court fee paid in such case shall be refunded. In the case of Punjab National Bank versus Lakshmi Chand Rai, Jaya 2000 Madhya Pradesh 301, it has been propounded by the Madhya Pradesh High Court that the decision and decree passed by Lok Adalat under the provisions of the Legal Services Authorities Act 1987 shall be final under section 21(2), and all parties will be bounded with that decision or decree. In the case of P.T. Thomas versus Thomas Job AIR 2005, it has been stated by the Supreme Court that the award of Lok Adalat is an order passed by Lok Adalat under consent of parties. Here no appeal lies from award of Lok Adalat. Permanent Lok Adalat. The constitution of permanent Lok Adalat is a new concept of settlement of disputes through compromise and agreement. It has been inserted in the Legal Services Authorities Act 1987 by the Legal Service Authorities Amendment Act 2002. Actually, it is a powerful form to settle the cases related to public utility service through compromise and agreement. Constitution. Provisions with regard to constitution of permanent Lok Adalat are mentioned under section 22B of the Legal Services Authorities Act 1987. According to it, the constitution of permanent Lok Adalat shall consist of one chairman and two other members. The chairman may be such a person who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of a district judge. Two other persons may be such a persons. Two other persons may be such persons who are having adequate experience in public utility services. The constitution of permanent Lok Adalat or the terms and conditions of the appointment of the chairman and other persons shall be such as may be prescribed by the central government or state government. The constitution of permanent Lok Adalat or the terms and conditions of the appointment of the chairman and other persons shall be such as may be prescribed by the central government or state government. What are public utility services? The following services are considered as public utility services under clause B of section 22A of the Act. Transport service for the carriage of passengers or goods by air, road or water. Postal, telegraph or telephone service, or supply of power, light or water to the public by any establishment. System of public conservancy or sanitation, or service in hospital or dispensary, insurance service. Any service can be any service can be declared to be a public utility service by the central government or the state government in the public interest by issuing a notification. What is jurisdiction? Provisions with regard to jurisdiction of permanent lok adalat are mentioned under section 22C of the Legal Services Authorities Act 1987. Section 22B is also related to jurisdiction. According to the provisions laid down in both sections, permanent lok adalat has jurisdiction of hearing of all such cases which are related to public utility services. But the permanent lok adalats will not have jurisdiction of hearing of such cases relating to an offence not compoundable under any law. Where the value of property in dispute exceeds 10 lakh rupees. The central government may, by notification, increase its jurisdiction in constitution with the central authority. As stated above that the permanent lok adalats will not have jurisdiction of hearing and settlement of such criminal cases relating to an offence not compoundable under any law. Solapur Municipal Corporation versus Relifer EIR 1970 Mumbai 333. Ramlal versus State of Jammu and Kashmir EIR 1999 SC 895. In the case of branch manager Hazaribagh National Insurance Company Limited versus Prakash Handa EIR 2012 Jharkhand 6, it has been held by the Jharkhand High Court that permanent lok adalat has no power, jurisdiction and authority to decide the disputes on merits without there being consent of parties. In the case of Dr. Ambika Kumari versus State of Kerala EIR 2012 Kerala 16, it has been propounded by the Kerala High Court that services of hospital are public utility services. When a case is under consideration with permanent lok adalat, then such case cannot be instituted in any other court. This trial of criminal case cannot be done by permanent lok adalat. In the case of Life Insurance Corporation of India versus Suresh Kumar 2011 2 KIT 970 SC, it has been stated by the Supreme Court that the permanent lok adalat is not a regular court authorized to adjudicate dispute between parties on merits summary. What is the methodology? Methodology of permanent lok adalat is detailed under section 22C of the Legal Services Authorities Act 1987. According to it, any party to a dispute may, before the dispute is brought before any court, make an application to the permanent lok adalat for the settlement of dispute, and after such an application is made, no party to that application shall invoke jurisdiction of any court in the same dispute. On making such an application, Permanent Lok Adalat shall direct each party to file a written settlement, to state in written settlement the facts and nature of dispute under the application points or issues in such dispute and grounds relied in support of or in opposition to such points or issues, to submit any document and other evidence in proof of such facts and grounds, to file additional settlement, and to send a copy of such statement together with a copy of such document and other evidence, if any, to each of the parties to the application. Thereafter, Permanent Lok Adalat will make efforts for conciliation between the parties. Courts and contemplation of Permanent Lok Adalat during efforts for settlement shall remain impartial and justifiable. Both parties can submit any document and other evidence in proof of facts and grounds of their favor. When the parties reach at an agreement on the settlement of the dispute, the Permanent Lok Adalat shall pass an award. Both the parties will sign the settlement agreement. Where the parties fail to reach at an agreement, the Permanent Lok Adalat shall, if the dispute does not relate to any offence, decide the dispute. Effects of award. According to section 22E of the Act, the award of Permanent Lok Adalat shall be final, binding on all the parties, deemed to be a decree of a civil court, not called in question in any original suit, application or executive proceeding, executable by the civil court by a majority of the persons constituting the Permanent Lok Adalat. What is the procedure of Lok Adalat? Procedure of Permanent Lok Adalat is mentioned under section 22D of the Legal Services Authorities Act 1987. According to it, the Permanent Lok Adalat shall, while conducting the conciliation proceedings or deciding a dispute or merit under this Act, be guided by the principles of natural justice, impartial, played justifiable role, followed the principles of equity, justice and good conscience. Hence, it is to mention that in settlement of matters, Permanent Lok Adalat is not bound to follow the provisions of the Code of Civil Procedure 1908, the Indian Evidence Act 1872. It has to follow the principles of equity, justice and good conscience and the principles of natural justice. In the case of Dr. Ambika Kumari versus the State of Kerala, IIR 2012, Kerala 16, it has been stated by the Kerala High Court that Permanent Lok Adalat is not bound by provision of Code of Civil Procedure and Evidence Act. It is required to follow principles of natural justice, objectivity, fair play and equity. What is free legal aid? Let's explain it. What is free legal aid? To make available free legal aid to the poor person is the duty of state and not compassion. Let's discuss this statement. Justice to all and availability of equal opportunity of justice to each person is the recognition of democracy. It is expected in democracy and rule of law that nobody should be deprived of justice, but it is possible only when the justice be cheap and speedy, so that it may be accessible for common man. It is bitterly truth that today's justice is costly and time-taking justice. A common person who is illiterate and poor does not access to justice. Many times the justice becomes mirage for him. He is unable to go to first stair of the court. The concept of justice becomes meaningless and redundant. This is the reason that measures for availability of justice are made in our constitution, and such provisions are made to so that the justice may be available to all persons. For the persons who are poor, arrangements are made to make available justice at the cost of state. Later on it was named as free legal aid. What is free legal aid? No worldly definition has been given to free legal aid up to now. Generally, it means to make available opportunities of free justice to such persons who are poor or who cannot access to court for enforcement of their rights due to poor economic condition. Justice is made available to such persons at the cost of state. This is a free legal aid. Such assistance may be in either form. To make available services of advocate without fee. To exempt or allow rebate in court fee. Free pleading by the advocate, etc. From time to time, various definitions of free legal aid are given as, according to E. Blackman, to give legal advice in a case to the poor or helpless person is legal aid. According to Sir Thomas Lund, to obtain legal advice from the advocate in a hard situation is a right. It is legal aid. According to International Legal Support Organization, legal aid is an assurance of this matter that nobody may be deprived of his rights only for the reason that due to poor economic condition or any other reason the services of legal experts were not available. According to Ontario Legal Support Act, the scheme of legal aid guarantees to each other. The scheme of legal aid guarantees to each person that a secured right is available to him for pleading by an advocate of his choice without worrying about the payment of fees. In the words of Justice P.N. Bhagwati, equal justice for all is an important concept. But due to poor economic condition is a hurdle in protection of rights of poor persons. Free legal aid is an instrument to provide equal protection before the law. It is clear from the above definition of free legal aid that free legal aid means availability of equal opportunity of justice each person. access of all person to the court, right to obtain advice from the advocate of his choice, not to deprive of from the justice due to poorness or any other reason. The concept of free legal aid is based on the formula of UB just EB remedium. Legal aid is a treatment. If this treatment is not there, then the presumption of justice is meaningless. Free legal aid in the Constitution. What is the free legal aid in the Constitution? A provision with regard to free legal aid has been made in Article 39A of the Constitution. The state shall secure that operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to secure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. In this manner, the main objective of Article 39A of the Constitution is to make available equal opportunities of justice to each person of the society. Its main aim is that any person of the society may not be deprived of justice due to poorness or any other person or any other reason. Free legal aid under the Code of Criminal Procedure. A provision with regard to free legal aid has also been made. In section 304 of the Code of Criminal Procedure 1973, according to it, where in a trial before the Court of Session, the accused is not represented by a pleader and where it appeared to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. Thus, the main object of section 304 is also to make available free legal aid at the expense of state. This section provides the right to be defend to the accused. Free legal aid under the Code of Civil Procedure. A provision with regard to free legal aid has also been made in the Code of Civil Procedure 1908. Order 33 provides in respect of suit by indigent person. According to it, any poor person can institute suit without making payment of court fee. Such a person is deemed to be poor for this purpose, who does not have sufficient means to pay the prescribed court fee for lawsuit and who does not have a property of more than rupees 1,000 except the property which cannot be possessed in execution of decree and disputed subject matter. In the case of Falmunisha Begum versus Dr.R.K.Singhmodi, AIR 2000 Andhra Pradesh 5. Such a woman has been considered poor by the Andhra Pradesh High Court, who has genuinely poor, who has undergone surgery which was damaged due to carelessness of medical attendants, who was not having any means of income. There were 2 children in her family and whose husband was also not having any source of income. Here it is also to mention that a suit can be Here it is also to mention that a suit can be instituted by a partnership firm like poor person as it is a legal person. Messrs. Nandkishore Mohanlal versus Messrs. Junjunwala and Company 1990 Madhya Pradesh 331. This right has also been provided to the This right has also been provided by Murthy Jogesh Chand versus Ishwar Bijlal, AIR 1981, Kolkata 259, and Guru Granth Sahib, Shiromani Gurudwara Manager versus S.N. Das, AIR 2000, SC 1421, being a legal person. Here sufficient means does not mean with sufficient property. Such means are not included in it on which the life of party and his family depends. Opinilam Hodri Works versus the State Bank of India, year 1994. Himachal Pradesh 11 free legal aid under the Legal Services Authorities Act. Free legal aid under the Legal Services Authorities Act. The Legal Services Authorities Act 1987 passed for free legal aid is an important statute. Sufficient arrangements are made in it for free legal aid for poor persons. Such persons who are entitled to get free legal aid have been mentioned in section 12. A member of a scheduled caste or a scheduled tribe. A victim of trafficking in human beings or beggar as referred to in Article 23 of the Constitution. A woman or a child. A person with mental disability or other disabilities. A person under circumstances of undeserved want such as victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disaster, or an industrial workman, person in certain kind of custody or in receipt of a determined annual income. The limit of income is changeable from time to time. In the case of Sugriv alias Jagdish versus Shrimati Sushila by AR 2003, Rajasthan 149. It has been held by the Rajasthan High Court that as soon as such a person whose mention has been made in section 12 institutes a suit as a poor man, he should immediately be intimated about his right to free legal aid. Adjudication. Our judiciary has also confirmed the right to free legal aid under its adjudication from time to time. In the case of M.H. Hoskat versus the State of Maharashtra, AIR 1978 SC 1548, it has been propounded by the Supreme Court that to make available free legal aid to the poor person is the duty of the state and not compassion. In the case of human attack Khatun versus the state of Bihar, year 1979, SC 1360, it has been held by the Supreme Court that to get free legal aid is fundamental right of a person. In such cases, the court should not wait for application of the accused. It is duty of the court that it makes aware with this right of the accused. In the case of Sukdas versus Union Territory of Arunachal Pradesh, it has been stated by the Supreme Court that it is duty of the courts that they make aware the accused with the right to free legal aid without waiting for his application. In the case of Kalaban Desai versus Allahabad Desai EIR 2000 Gujarat 232. It has been decided by the Gujarat High Court that to make aware with the right to free legal aid to the parties is the responsibility of bar and bench. In the case of Dilawar Singh versus the State of Delhi IR 2007 SC 3234, it has been held by the Supreme Court that where there is no advocate of the accused in the criminal trial, an amicus curiae should be appointed by the court. In the case of Mohammad Hussain alias Zulfikar Ali versus State IR 2012 SC 750, the accused was prosecuted and punished for serious allegations without making available an advocate for him. The conviction and penal order was set aside by the Supreme Court. It has been stated by the court that punishing without making available the OAT. It has been stated by the court that punishing without making available the aid of advocate to the accused is not justifiable. At the last, it is conclusion that each person has right to defend. If a person cannot appoint advocate due to his poorness, then such person is entitled to get free legal aid. Dear friends, tomorrow we will discuss a short note on para-legal services. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainers, professor, professionals, research learner, officer, official. I thank all respected doctors and directors. I thank all honorable minister manager. I thank all honorable advocates, secretaries, administrative advisors. I thank the present Mr. Modi. Thank you very much. Thank you. Thank you.